Maplewood City Council meeting of Monday, December 15th, 2008. Ms. Juneman is running a little late, but she had asked that we start without her. She will be joining us shortly. With that said, we do have 4 of the council members present, so we do have a quorum. First item is the approval of this evening's agenda for this 5 o'clock meeting. Mr. All?
Mayor and Council, the agenda calls the first item for a declaration of going into closed session. I think that issue in itself needs to be debated. And we have both of our attorneys here this evening, along with Mr. Bernard. Discussion of the information that we have and the ability to debate it this evening in closed session is before us. So I believe the agenda is appropriate, saying that the intent to close session, but I think the first item we have to have is a fairly detailed discussion on whether there is basis to go into closed session. And so that would be the first item that we will need to take up, and it may determine what the rest of the agenda and what we can do for the rest of the agenda. So I'm not sure how you want to handle that, other than I think the first item we need to do is have a detailed report from both of our attorneys on the issue of whether we have the authority to close this session.
Right, okay. So it sounds like that's not really changing the agenda. That's just talking about what some of the discussion points should be if indeed we close the agenda.
That is correct, ma'am.
Okay. Are there any other items of substance that we should note on the agenda?
I'll move approval of the agenda.
I'll second that. So we have a motion and second before us. Any further discussion? Hearing none, Mr. Jelly, first to vote.
Aye.
Mr. Rossbach?
Which agenda are we approving?
You might be looking at the one for Thursday.
The 5 o'clock.
Okay. We're meeting on Thursday, apparently? Okay. Aye.
Aye.
Okay, unless you had discussion points.
No, I just
Okay,
had
very good.
something else that was here that was confusing.
Okay, and then also mayor votes aye. Okay, so with that said, then we have our agenda approved, and so then we are moving on to unfinished business. And the first item of unfinished business that we're talking about tonight is regarding the discussion with our consultant, who is here tonight from PAR Group, Mr. Steve Bernard. We're going to be talking about the semifinalists for the new city manager. So, legal reports, please.
Thank you, Madam Mayor. I'm going to try and bring us out, at least start the discussion in any event. Before you, of course, is the city manager search process. I believe you have some semifinalist information with you tonight, and a discussion was had before the meeting regarding how we should best discuss those candidates. And Steve Barnard is here, our consultant with the PAR Group, and I believe that the initial matter was one of keeping the identities of the semifinalists confidential, as we must, given that that isn't considered public information until you've reduced the plank of candidates down to a group of finalists. And the way that it's been done historically is to close the meeting to discuss those semifinalists in order to absolutely maintain that level of privacy in their identities. And the discussion was, should we do that in this case? And due to the fact that that is confidential information and or at least non-public information, certainly the absolute rock-solid method of keeping them private would be to close the meeting. Unfortunately, under the open meeting law, it does appear that there would be potentially a less complete method of doing it, which would be to number the contestants and talk about them by way of number and not give any specific references to personal data or other data that would otherwise reveal them, such as, if someone is currently the city manager of, XYZ city and XYZ state, and how are they going to be, perceived as quitting their job if she was to come here. Clearly that's going to identify that contestant without ever having to name them, which is obviously a divulgence of that information and something that would potentially cost that person their job in whatever city that they're at now if they weren't picked. So there's the tension, and one way around that was to refer this to a body that isn't subject to the open meeting law. The other way is to simply go into closed session under a reading of the labor negotiations strategy exception to the law and close for that purpose. Obviously, there's been some tension brought up by you, Mayor, with respect to that particular exception, given that by at least some people's read, that's not considered a negotiation between labor and management as a question of union negotiating. So that's kind of an introductory speech, if you will, as to where we're at, and it's really a question left up to you folks as to whether or not you want to try and close the meeting and have the discussions yourself, or refer this on to another body that wouldn't be subject to the open meeting law. So with that, I'll turn it over to Mr. Bethel, who's the labor relations attorney, and he can fill you in with the other half, I guess you could say, of what we have to report.
Thank you, Alan, Mayor, members of the council. I basically concur with everything Alan has said here today. The choice, I think, is we number the candidates so that we don't divulge the private data, or if we refer them to the two subcommittees that were formed, and let Mr. Bernard go through the winnowing down process and come up with a slate of 5 or 6 candidates. They could do that in a setting that wouldn't be subject to the open meeting requirement that this body is. I think when they come back with that slate of candidates, it's still this body that will make the ultimate decision. This would still be the decision-making body that would decide to accept their slate or not, and then, of course, ultimately make the decision on hiring the new city manager. I think that that's where we're at.
And I'll just add on to that you do have a memo before you that takes a look at an iPad decision as well as a Supreme Court case from, it's getting to be 20 years now, but I believe is still good law. And that specifically discusses, council, the propriety of having panels essentially named by you as a city council to assist in the city manager search process. In the case of the materials that I gave to you, it wasn't a city manager search, it was a university presidential search. But there was at least one group or one committee that was named specifically to assist the decision-making body, which would in this case be analogous to the city council. And in that case, I believe a newspaper sought to have those meetings of that group open, and the Supreme Court ultimately said that no, there's no decision-making authority in that subcommittee or in that committee, and therefore they aren't subject to the open meeting law. And that was the decision, and as far as I know, that's still good law. And I would liken that committee to those panels that you have set up to assist you in this process. So I believe that I believe that our consultant could make his initial presentations to those panels, whether it be together or separately, and they could meet privately and discuss the qualifications and whatnot and make their references back to you or their recommendations back to you. So that being said, I guess it's up to you folks to make the ultimate decision as to how you'd like to proceed.
I believe, council, if I might just summarize
Mr. All.
the issues, council, is explained to me. Number one, for you as a council tonight to go through and discuss candidates 1 through 12. That would be how you would have to refer to them. Closing the meeting does not appear to be a reasonable option for the city to take at this point in time based upon what the attorneys have said. However, and I think it would be very risky for you as a council to try to say, gee, candidate 7 is from the city of whoops, and any slip like that could start exposing us to a breach either with the PAR group. The PAR group then comes back and said, no, it was the city. Should we then get exposed to releasing the confidentiality of the names? So the suggestion that we're making through the attorneys and through Alan's and Chuck's opinion is that the panel actually take the list of these 12 names, review them, go through their process, and then recommend back to you out of these 12 a ranking, and that you then select those 5 who then become public. Those 5 names become public, and then you, through the public process, would do the interviewing of those 5. And so that's really what we're talking about. And I think one other item is that because the panels do not have decision-making power, that not only while